Yesterday, November 11th, 2025, OpenAI lost their first copyright case. A German court ruled they committed willful infringement by memorizing and reproducing song lyrics. But here's what they're not telling you. This is just the beginning. Because while Sam Altman is asking for AI privilege, claiming talking to ChatGPT should be legally protected, like talking to a lawyer, courts just gained access to OpenAI's internal Slack messages. And those messages, they reveal a deleted data set of pirated works, books from Library Genesis. The same data set that just cost Anthropic $1.5 billion to settle. I'm going to show you why OpenAI's business model might be dead, why every creator on the planet should care, and how a mathematical equation called pi is converting corporate theft into apprenticeship funding. Let me give you the numbers, because they're stunning. Under U.S. copyright law, 17 U.S.C. Section 504, standard infringement damages range from $750 to $30,000 per work. But when infringement is willful, meaning the company knew they were stealing or showed reckless disregard, that number jumps to $150,000 per work. And here's where OpenAI is in serious trouble. They scraped tens of millions of copyrighted works, books, articles, song lyrics, and artwork. Do the math. Millions of works times $150,000 equals billions and potentially trillions in exposure. The New York Times is suing them. George R.R. Martin, John Grisham, and hundreds of authors are suing them. 8 major newspaper publishers are suing them. German courts, Canadian courts, Indian courts, all moving forward. And those internal Slack messages the court just unsealed, they show employees discussing the deletion of that pirated book data set. That's evidence of willfulness. Anthropic saw the same evidence in their case and settled for $1.5 billion rather than go to trial. Sam Altman admitted on record that building ChatGPT without copyrighted content is virtually impossible. So they built it anyway, and now the bill is coming due. But here's the part that should terrify every creator watching this. You're not the New York Times. You don't have their legal team. You can't afford to sue OpenAI or Meta or Google when they scrape your work. And they are scraping your work right now. Automated bots crawl the internet 24/7, downloading everything they find, your photographs, your textile designs, your writing, and your music. They train their AI models on it. Then their AI reproduces versions of your style, your techniques, your creative voice, and sells it back to the market that used to pay you. Cambridge researchers just proved that even supposedly protected artwork with tools like glaze can be bypassed with 99.98% accuracy. So what's a creator supposed to do? Just accept that your life's work is free training data for billion-dollar corporations? That's where most people would end this video, with despair. But I'm going to show you something different. There's a mathematical constant called pi, 3.14159. You know it from geometry. But here's what you don't know. Pi creates natural rhythm that humans can flow through, but automated scrapers cannot. It's called a mathematical harmony barrier, and here's how it works. If you limit requests to pi per minute, 314 requests, human browsers naturally comply. You click, you read, you browse, no problem. But scraper bots, they operate in consistent intervals, 30 seconds, 40 seconds, robotic precision. When they hit a pi frequency barrier, they self-document their violations. 4 requests in 7 seconds, that's not human. That's automated theft. And here's the beautiful part. These violations create evidence of willful infringement. Remember that $150,000 per work number? Your barrier just documented it. Time-stamped IP logged, self-incriminating. We call it the ice chamber. Corporate scrapers swim in, the mathematical frequency catches them, and they freeze themselves in legally admissible evidence. One company hit our barrier 4 times in 7 seconds. Let me show you what I mean. My own website, greenstudiocreations.studio, has been live for 3 months. We've tracked 717 total visitors. The mathematical harmony barriers identified 494 humans. That's 68.9% authentic traffic. But here's where it gets interesting. The other 31.1% bots, and we caught every single one. 7 scraping attempts tried to steal the product catalog. All 7 attempts frozen in what we call the ice chamber, and then converted into qualified business leads. One bot, IP address 172.31.96.226, was making requests at exactly 30-second intervals. Perfect robotic timing. The pi frequency barriers caught it immediately because humans don't browse like metronomes. Even Google Safety came by to check us out, and we passed. And here's the judo economics part. Those companies that tried to scrape our data, they're now negotiating to pay for legitimate access. We converted theft attempts into revenue, and that's the whole framework. And don't forget the apprenticeship guilds. In seconds in October 1st, documented invoice ready. But here's where it gets interesting, because we're not just building a lawsuit factory. When a corporation gets caught by our mathematical harmony barriers, they have 3 choices. 1, ignore it. Just scraping. Face the legal consequences. $150,000 per work. Willfulness proven by your own timing patterns. See you in court. 2, fight it. Hire lawyers. Spend millions on litigation. Risk having your internal Slack messages subpoenaed like OpenAI. Gamble on a legal precedent that's currently breaking against you. Germany just ruled against OpenAI. U.S. courts are letting cases proceed. You might win, but Anthropic locked the same gamble and paid $1.5 billion to make it go away. And 3, license it. Pay an annual licensing fee. Contribute to the Creator Chest, a fund that pays for apprenticeship programs and heritage guilds worldwide. Get legal access to the content you were scraping anyway. Avoid the lawsuit. Get positive PR for supporting artisan heritage preservation. Turn your guilty conscience into good press. Most corporations will choose option 3 because it's cheaper than fighting, cleaner than losing, and converts a scandal into a story. We call this judo economics. Use the corporation's own force, their scraping power, their speed, their greed against them. Convert their attack into revenue for creators. They either play ball and find apprenticeships, They either play ball and fund apprenticeships, or they pay statutory damages and face legal warfare. Either way, creators get funded. OpenAI just lost their first copyright case, and more will follow. The Slack messages are unsealed. The settlements are piling up. But here's what's really happening. The age of free creator content is ending. Corporations are learning they can't just scrape everything and hope no one notices. Courts are learning that AI training isn't automatically fair use. Creators are learning they have leverage. And mathematical harmony barriers, they're converting corporate theft into apprenticeship grants for traditional textile artists, metal workers, wood carvers. The heritage guilds keep humans' craft alive. 360-degree win. Creators protected, apprenticeships funded, corporations given an exit ramp that doesn't destroy them. The framework is called Finding Human. It's open source, and it's alive. Because when Sam Altman asked for AI privilege, we're building creator protection instead. High-frequency barriers, self-documenting evidence, and judo economics. The copyright war isn't over, but creators just got a weapon that uses math, not lawyers. And that changes everything.